Good afternoon. So let's start with a couple of administrative things. The first one is what's happening with tutorials this week? For this class, what's happening with tutorials?
You said that we're done this week?
Say it again, louder.
You said that we're doing tutorials this week?
Yes, that is correct. There are no tutorials this week. Where have I announced this?
Class.
Announced it in class. Have I announced it anywhere else?
No.
In e-learning on the announcements forum, which you should be getting via email.
Yeah, you sent it in email.
Right. So why am I still getting emails asking why I can't log into the tutorial this week? I'm not going to call anybody out. I'm not gonna name names. I'm not gonna ask anybody in particular. I'm just saying, perhaps if you have a group chat that I'm not a part of, which is fine, I'm not asking, okay? Perhaps you should let your colleagues know that when they don't attend lecture and they don't check the announcements forum, they're gonna have problems. This one, the only problem is I get emails that aggravate me. But there may be other times where you'll miss a deadline or you won't submit something that needed to be submitted, and then you'll have a real problem, right? Aggravating me, not a big deal, but other things, big deal. Other administrative things, I have begun marking outstanding work. I got through all of the submissions for the icebreaker from those who submitted through lecture 1. Now, if you are enrolled in lecture 1, you may have also submitted through lecture 2, and I have not gotten to those yet. I want to go ahead and warn you that if you are enrolled in lecture 1 and submitted through lecture 2, when the marks are released, you're going to see a 0. Don't worry about it. Don't panic. Okay, and I will send an announcement about this once I finish all of the marking of these. But because the submissions for the icebreaker are split across both lectures, if you're enrolled in lecture 1 but submitted through lecture 2, when I marked lecture 1, e-learning told me you had no submission. And it took me a while to figure out that there were people who had a submission, but it was just in the other lecture. So don't worry if your mark on that assignment comes back as a 0. you're probably marked in the other lecture. If you didn't submit it at all, please do that. You're being marked on completion, by the way. There's no right answer to any of those. So if you submitted it, you got full marks. Okay. That's everything I have administratively. Okay. So this week, we're going to continue our discussion of the fixtures doctrine by specifically talking about chattel houses and how chattel houses have evolved the fixtures doctrine in the Caribbean and how it can continue to evolve in other ways. So let's start by asking a question that is going to seem so dumb that you're not going to be sure what the right answer is. I say this because every time I ask a dumb question, students go, it can't be that simple. Yes, it can. I promise it can. What is a chattel house? Yeah. Yeah. It is a house that is not affixed to the land it sits on. Adriel, we have moved on from the icebreaker. We've moved on. We're now talking about the actual course. Email me, Adriel. Email me. Okay. So, yes, a chattel house is a house that rests on land that it is not affixed to. And under the common law of the Caribbean, these items, these houses, these structures are treated as chattels. Okay? Just out of curiosity, and it is totally okay if the answer is no, has anybody read the Simeon McIntosh article that is on the syllabus? It is okay if the answer is no, because it doesn't exist online. For reasons that, to be perfectly frank, surpass understanding to me. The Caribbean Law Review is not digitized. It is only published in hard copy. And because Professor McIntosh published this article in the Caribbean Law Review, it does not exist online until I get around and scanning the hard copy that was given to me by another faculty member. I can't find it myself. If it hadn't been given to me, I wouldn't have it. I have not gotten a chance to scan it yet, so do not. Yep, you're all saying the exact same thing, that you can't find it, and you're right, you can't, because it doesn't exist. At least as far as the scholarly conversation is concerned, because in the year of creation 5781, right? Scholars look things up on the internet. We don't go wandering the shelves of the library reading volumes of law reviews. So I don't expect you to have read it. Let me summarize it for you. And I would give you some things, some visual aids here on the board, but some vandal ahead of me has marked it up and failed to erase it. So, and I didn't bring my eraser with me, because why would I do that? Because of course I was going to be the vandal who didn't erase the board. Okay, so let me summarize McIntosh's argument. He spends some time sort of walking through the development of the chattel house doctrine, okay, including a fairly lengthy discussion of the facts and the analysis in Mitchell versus Cowley. Trinidadian case that sort of is regarded as one of the leading cases for the chattel house doctrine, despite the fact that the structure in Mitchell wasn't ruled to be a chattel house. So, but it explains the test sort of very clearly, and most of the subsequent authorities, as near as I can tell, have relied on it. So in the Mitchell case, it's a little bit of a complicated chain of title, but basically the tenant sells the structure and their right to the land to someone else. And then the landlord wants to combine the land and the structure. Okay? That's the facts. That's the facts of Mitchell. Simple. Okay? Again, there's complications involved. They don't matter. Okay? So the Court of Appeals or the Court of Appeal for Trinidad and Tobago are asked the question, is the structure a fixture? And what does Mr. Justice Wooding conclude? He concludes that it's a fixture. Why? Okay, let me start by me ask a different question. Rather than asking, like, recapitulate Justice Wooding's reasoning without, because the case itself is also not available online. I checked. You can't get it through Carolaw. It has not been digitized yet. I don't know if the library has plans to sort of reach back in time and digitize older cases. But they haven't gotten to that one yet. So rather than ask the question, tell me what Justice Wooding's reasoning was when you haven't read it, why would you think that this house in this circumstance would be classified as a fixture? Yes, Travis.
Before I answer a few questions about the house, you said it was a child house, so not attached to the land itself.
That appears to be what the record suggests.
I'm assuming, did they specify how many years was there?
I'm sorry.
Did they make any timing specifications as to how long the house was there?
It was actually never finished. So this was an ongoing construction project that never actually was finished and inhabited.
Considering I haven't read the judgments for that case,
Of course.
I would assume that the reason why it can be classified as a fixture is because it doesn't show the purpose as a child within that one lived in it, and the fact that it was being constructed on the property but not attached to the property itself. It would be classified as a fixture because the purpose of the child which does have immediate use upon reaching the land. For example, that chair, it is used as a chair, you have to build it on the land. So I would assume they classified it as a fixture on the basis that was in the process of being constructed on the house. And you said it took some time, it was not traditional inhabited, so it would be a fixture in that sense because the house was used as a chassis. Does that make sense?
It makes sense to me. I'm just checking the chat. Yeah, Michaela, I mean, you're absolutely saying the right thing, right? You're explaining the test. Absolutely, that's correct. I'm pointing at my screen like you can see me. You can, but like me pointing at the screen means anything. So to answer the other question that came in, Travis's argument is that the chattel house in this case can't be treated as a chattel house because it's not a house. I'm sort of rephrasing your argument, but that seems to be basically what you're saying.
Yeah.
Okay. It's not a house. It's never been dwelled in. It's under construction. And so it can't meet the definition of being a dwelling. And since the dispute arose, now it's a fixture. This seems to be Travis's argument. Does anybody think that that's a problem? I mean, I think Travis's argument makes sense, right? I just want to be clear about that. I think it makes sense. But I think there's room to push back. What do we think might be a reason to be skeptical of Travis's analysis, which is otherwise sound?
I guess by that same logic, what would make it a fiction? What would describe it as a fiction? I guess that would be
I think that's one issue. Monique, what did you think? So for those of you in the chat, Travis sort of asked, well, what makes it a fixture, right? And the answer is nothing. But if it's not a chattel, it must be a fixture, right? Is sort of the logic, I think, as I understand it. So, Monique?
The question, what it was about, so what makes it not a house?
Yeah, what makes it not a house is a reasonable question. The answer, of course, is because it's under construction. It's not fit for habitation yet. Yeah, no, you guys are hitting on the right question, right, in the chat. Nicole and Aija, I hope I've pronounced that correctly. That, please let me know if I didn't. That the question in all of this is, what's the intent? Okay. One question that I think may be helpful here is whose intent matters. Because one of the things that I think is a really interesting and relevant fact in is that I totally butchered your name, or you're not going to tell me if I got it wrong. Sorry. Well, I'll move on. The parties in the actual Mitchell case are not the people who built the structure, right? One of them is the landlord, who was not, or the landlord's successor in interest, actually, I think. The other one is this other person who bought the house and the lease from the affixer. So whose intent matters in determining whether the structure is a fixture? Is it the intent of the landlord? Is it the intent of the person claiming the chattel? Is it the intent of the absent affixor?
mediation.
Yes.
in terms of the absence of fixer because they initiated the process of building up in the first place.
Yeah. Yeah. This, I think, is really, if I'm being honest, again, like Travis, without having read the judgment, but having the benefit, unlike I think most of you, of having read Professor McIntosh's analysis, I think this is why the Court of Appeal determines that the structure is a fixture. And by the way, I think that it's reasonable to conclude that the Court of Appeal got it wrong, that Justice Wooding was incorrect. I also think you can reach the conclusion that he's right, and certainly even if, whether he's wrong or right on the outcome, certainly he's accurately stating the doctrine, okay? But I think that by relying on the intent of the affixor, which is nowhere evident in the record and is being sort of drawn out of these other facts to try and create the objective intent, I think that the Court of Appeal very likely gets it wrong, right? Okay. So we see this case. Professor McIntosh walks us through some of the statutory components that affect the tenant's right to remove, right? We discussed last week the common law right to remove. We discussed how statutes affect that. Professor McIntosh goes through that in great detail. And you can actually, well, anyway. Nicole asks, would custom and usage have affected the decision? Well, what do we think? No, seeing no's. Okay, Monique, why not?
Because it wasn't, a house that they had said had no custom and it wasn't in use.
Well, I mean, I don't disagree with anything that you've said, but remember, custom and usage is about the ways in which contracts and property are executed and used and enforced in the community where the case arises. It's not about the specific use of the specific item, right? It's about sort of looking more broadly out to the community as a whole, okay? So do we think that the custom and usage, I mean, I'll throw this out to the Trinities in the room. You know, what do you think is the right answer under custom and usage? So Nicole says it's usually a fixture in the Caribbean. Anybody else want to chime in? Okay. I mean, I don't have any reason to dispute that analysis, right? That, you know, these things would usually be fixtures. So, but I think that raises the question of what do we do with these chattel houses if they are usually fixtures and tenants build them for themselves? What happens when the lease is up?
I guess a lot of them have the ultimate right or authority to get off this property.
To what?
The landlord, like owner of the land, would have the right then to get it off this property, not necessarily to keep it or seize it as his own, but
If it's a fixture, he absolutely has the right to seize it. right? That's the common law. If it's a fixture, it becomes part of the land, okay? And it's only, the common law right to remove only applies to trade fixtures, right? So the landlord's right under the common law is absolutely to keep it, right? Now, again, we have the statutes that we talked about that provide tenants with rights to remove under certain circumstances. Okay? So Bettina points out that the decision in Mitchell is very strongly affected by the construction materials that are used and the ways in which they are attached to the land. I think that's probably right. I think that's probably right. So Donnie, you're saying that you move the chattel house. But if under the law, this is a fixture, it no longer is movable. It now attaches to the property. It belongs to the landlord. How do you reconcile that? You're welcome to come off mute and
The fact we have here in Barbados Caribbean is that banks lend you money to build chattel on person's land if they can prove that they will be able to move it if anything happens. So really and truly, it remains a fixture, and it commences as a fixture. So I would say that when they got issues, you move them.
but again, right, the point of the doctrine is that fixtures don't move. Fixtures stay on the land because they become part of the land. So how do you move a fixture?
Well, I'm saying,
How do you move a fixture lawfully? Because obviously we can sort of say, okay, well, maybe we do it just sort of in the dead of night, and then the next day we go, what house? There was never a house here, you know.
well, here you move a church lawfully by buying it. If it can be moved, and it's a fixture, you buy it and move it. But I'm saying the bank allow you to build movable things that do not become fixtures.
Oh yeah, no, absolutely, right? That's correct, that movable things, right, don't become fixtures. But as we've said, the structure in Mitchell was considered a fixture, and Nicole has pointed out that most structures are regarded as fixtures. And as I understood her comment, was that she was including chattel houses in that. I may have misunderstood her. And so if that's the case, where does the doctrine come from? How do we, let me sort of expand on what I'm trying to ask more generally, right? We know that there is this chattel house doctrine. We know that there are people in the past, maybe even now, right? Maybe even in the year of creation, 5781, who live in temporary structures that are not attached to the land. And that they have the right, if in the event that they lose the ability to occupy that piece of land, they have the right to move the structure. Okay? We know that this is a thing that happens. But the position that's been asserted by Nicole, okay, by Nicole, that I'm sort of throwing out here for us to talk about, is that most structures are regarded as fixtures in the Caribbean. Now, I will be very honest with you. I do not know enough about the ins and outs and the details of the cases across the Caribbean to tell you whether or not Nicole's statement is true. Okay? But if we assume that it is, can we reconcile the known sociological fact that houses move in the Caribbean with this statement of law that most structures are fixtures? So we're continuing to see more discussion of the construction of the house in Mitchell, that it's built in a significantly more substantial way than traditional chattel houses. And so this is why it's a fixture. Does this sort of comport with what you guys think might be going on, your understanding? Yes, no, maybe? Are these definitions subject to policy considerations in the Caribbean context? Consider chattel houses as chattel, given that at one point that was. So, Nicole, I'm going to answer your first question, and then I'm going to ask you to rephrase the second one because I'm not sure what you're asking in the second one. But the first question, are these definitions subject to policy considerations? The answer is always, right? To the extent that judges will consider policy considerations, which in more traditional common law jurisdictions like the UK and Australia can be quite common. In jurisdictions where the system has sort of stepped away from the common law, like the US, policy considerations can be very hard to convince a judge to consider. But regardless of what judges will or won't consider, okay, the legislature always has the power to enact statutes that attempt to define these terms and can consider whatever policies they want, right? That's the great thing about being a legislator is you never have to explain yourself. So I don't quite understand your second question, Nicole. I want to be honest, so why don't you explain it?
Can you hear me? Can you hear me?
Barely. Can you speak up or get a little closer to the microphone?
Sure. So no, the issue I was asking about is we know, for instance, with the leasehold, it wasn't always considered as property, but for reasons of context, it then changed into that. My question about the chattel house, when I asked about policy considerations, is whether in a context like the Caribbean, whether you would legislate, whether you would consider a chattel house chattel, given the socio context, whereby at one point this was the house capable of being built. I mean, this was the definition of a house. This was it. It wasn't anything more permanent than a chattel house. So in that context, would you legislate that type of house as being chattel, or would you legislate it as being a fixture?
So I think the first thing that I want to do is I want to push back a little bit on your historical understanding, right? And this is not, I'm not saying that anything you've said is wrong. I just want to tell you a little bit about how Professor McIntosh describes where the chattel house doctrine came from and how it developed. And this is post-emancipation, right? There was an effort by newly emancipated enslaved persons to acquire living space. But who owned all of the land In the islands, of course, it was their former owners and who still owned the plantations, and who had an interest in securing a labor force now that they could no longer force labor. That pun was unintended, by the way. So what they did was essentially the development of the Chattel House Doctrine was an outgrowth of the attempt by plantation owners to impose a sharecropping system, similar to what we saw in the American South. And it was vastly more successful in the American South because there wasn't the development of the Chattel House Doctrine. Okay, one of the things that makes sharecropping work as a system of oppression is the ability to throw out your tenants and leave them with nothing but the clothes on their back. But the Chattel House Doctrine developed a way for tenants who lost the right to occupy a piece of land to go and occupy a different piece of land and still have a dwelling. Okay, so it's not entirely true that there was a point where the Chattel House was the only house, like it was a house. Okay, there were plantations in the Caribbean before then. Okay, the Chattel House Doctrine develops as a mechanism to push back against the plantation owners. How successful it was, we're not going to evaluate that. But that's Professor McIntosh's argument for where the doctrine comes from. That it's a way for those of lower resources, okay, lower income, lower assets, lower wages, to exercise control over their dwelling, even though they're unable to secure land. So with that in mind, okay, Nicole, do you think that a legislature would be more likely to legislate chattel houses as chattels or as fixtures?
Well, it depends on the time period. I mean, the time period where you had the people living on tenantry land, basically. At that point, I would see that the legislature would rule in favor of the ruling class, because you want to be able to have these people move whenever you want. But I'm thinking at a different point in time, out of that time period, where you're trying to enfranchise a certain class of person, well, then you may consider it a fixture so that you can't just throw people off the land.
I think I'm going to need you to expand on this a little bit. Explain to me why classifying the chattel house as a fixture would keep a landlord from throwing someone off their land.
No, I mean, in terms of giving rights to the person who owns the chattel house, not because if you can just, to avoid the sharecropping situation that you described, if it's chattel, you can just take it and throw it off. But if you're seeking to give some kind of property rights to the owner of the chattel house, isn't that a way that you could do it? By saying that if you affix whatever is with the land goes with the land. I'm assuming ownership is, the person owns the house and the land.
Right, Nicole. I think you're mixing it up though, because the owner of the land is not the builder of the chattel house. So the person who's building the chattel house is just renting the land, or renting. They're a tenant of that person who owns the land. So if you make the chattel house a fixture, they would have lost everything that they put into the structure. because it would now become the landlord's property. And they
So
would
this is
own it anymore.
correct. So Kalana's absolutely correct. But I want to tell you a story about a case where what Nicole described actually happened. Okay. And this was the dismantling of Bishop Estate in Hawaii. So without sort of going through the details, Bishop Estate at one point, Bishop Estate is the descendant of is the trust that descended from the royal family of Hawaii when they were deposed. And at one point, almost 1 in 8 residents of the state of Hawaii were renting land from Bishop Estate. Okay. The state of Hawaii passed a law converting all of those leaseholds to fee simple. Okay, so this is almost exactly what Nicole is talking about, of granting tenants rights to the land through political action, right? Because of the mechanism because of the power of the state and because of the interest in securing property for those who are using it. Okay, there's a massive scandal, led to a huge case at the United States Supreme Court, which eventually ruled that the state of Hawaii had the right to do this as long as they paid Bishop Estate the fair market value. Okay, that has to do with American constitutional law. Is not worth discussing here. The House of Assembly in Barbados, or the legislature, whatever the technical name for the legislature is in St. Vincent or Guyana or BVI, right? Well, not in BVI, but any of the independent countries in the Caribbean, absolutely has the power to declare that a chattel house on a piece of property becomes a fixture and the tenant acquires title to the land. That is absolutely a power that the legislature has. I did read something in Professor McIntosh's article that there is a statute somewhere in the Caribbean where the establishment of a chattel house creates a 30-year lease with an option to renew that is at the sole option of the tenant. I can't remember, to be perfectly frank, where that statute was and whether he's talking about it as a proposed statute or whether it was actually enacted. But I do remember reading that, okay? So Professor McIntosh says, how do we fit this doctrine into the broader body of property law? This is where, if you are looking at the title of the article, this is where it becomes a Hegelian jurisprudence. And if you saw that and you went, oh God, you had exactly the same reaction that I did. Because Hegel is notoriously difficult. Let me see if I can give you the broadest of broad strokes, okay? Hegel's argument, according to Professor McIntosh, is that the act of being yourself, the act of being a person with self-will implies self-ownership. Does this sound familiar so far? Does this sound like something we've talked about maybe? Yeah? Okay. Yes, that's correct, Chris. Trisha, I saw your question. The answer is that what Nicole is describing is actually almost the opposite of the statutory right. So the statutory right is the right to remove fixtures that the tenant places on the land subject to the landlord's right to buy the fixture. What Nicole is suggesting is that the act of attaching a fixture acquires the land. Okay. Okay, back to to Hegel. The act of self-ownership is the most fundamental piece of being a person. But persons, individuals, are constructed in a society. As John Donne said, no man is an island. Okay, and then some other stuff that I never remember. So no man is an island. We all exist in a society, and the way that we know that we exist is through mutual recognition. Okay? So I recognize that when I swing my hand, when I come up against Travis's shoulder, I say that because he's sitting I think he's the closest person to me. That stops, right? There's a volume of space that I can't occupy. And I recognize that. And I go, Travis, this volume of space is you. Travis goes, yes, get your hand off me. There's a plague. Don't you know anything? Sorry. Sorry, I don't mean to pick on you. So this is essentially Hegel, right? Is that this is how we learn that we're people. And we extend our personhood to our stuff, okay? So we know that we're people because we have a mask, and it's my mask, and it's not your mask, and don't touch it, there's a plague, right? And we know that we're people because I have keys, and these keys allow me to access things, right? My car, my house, my office, my parents' house in the United States. Awkward. Why do I still have that? Anyway, this is why property exists. This is why Hegel describes property as a fundamental aspect of personhood, right? It's the act of knowing, the act of being a subject that relates to things, to objects, okay? So there have to be objects out there for us to relate to. And the way that we relate to them is as property. We recognize that certain objects belong to certain subjects. Sometimes that subject is ourselves, sometimes it's other people, okay? If this is complicated, or if this seems confusing, that's because it is. It's okay. And if we don't quite get it, don't worry, okay? So, just a couple of things that I want to sort of throw at you guys to think about, and then we'll talk about them on Thursday, and we'll talk about them a little more in tutorials next week, okay? According to Professor McIntosh, as he understands Hegel, property is the first embodiment of freedom. And the question that I want you guys to be thinking on over the next couple of days is, first, do you think that this is correct? That property is the first embodiment of freedom? Okay. Second, even if it's correct, does it matter? Do we care? Right? Let me ask a question to try and draw you guys out. Why am I asking, do we care? Why am I asking, do we care if property is the first embodiment of freedom? Go ahead, Denisha. I don't know. I mean, that's a fair answer, right? Yeah, to some extent, right? Why am I asking you this is asking you to read my mind, okay? Because property is power. Not a fair, not a bad answer. In general, if you're confused as to why I'm putting something in front of you, it's usually because I'm trying to get you to think about power implications. But in that case, let's follow up and go, how does property being power give us a reason to care about this? Having property, well, once upon a time that was correct, Tiani. Having property gave you voting rights. Once upon a time that was correct. Most democracies have transitioned to more or less universal suffrage. I don't know of any that still have property qualifications, but there may be some out there. So, okay. So here's why I'm interested in whether we care about whether property is the first embodiment of freedom. You guys are trying to become lawyers. I think, I hope. I think that's why you're enrolled in this degree program. In practice, you will never, ever, ever be asked to explain the Hegelian conception of self in order to justify a real estate transaction. Never, never gonna happen, okay? So, it is worth asking, is this something that we should even be bothering with? Is this worth our time? And that's the question we're going to start with on Thursday. So, see you guys then. And yeah, no tutorials tomorrow or Thursday. And we'll catch you on the flip side. Yes, Chris, tutorials next week are on fixtures. The questions are up on e-learning. They're labeled the wrong week. I'll fix that. So, all right, thanks so much. See y'all on Thursday.